Good morning, everybody. Today we're going to talk about getting ready to file for disability. There's a couple of steps I think that everybody should be aware of before taking the steps to file for Social Security disability. So I think what is really important is that you prepare yourself rather than just simply jumping online and filing a claim. A lot of times that does not end in success. Now, a lot of times too, the disabling condition is brought on suddenly, but there are a few steps that you can take right away to help improve your chances of success. So I think that the first thing you ought to do is, if you're still working, speak to your employer. If you have a long history of work, you have sufficient work credits, you're going to end up qualifying for SSDI. That's the disability you've been paying in on your FICA taxes. And if you're making under $1,130 a month gross, you're not engaging what's called substantial gainful activity. And that's the first step that you have to overcome in the 5-step process of being found disabled. So you have to make a decision. You either have to stop working or you need to reduce your hours to such an extent that you're making less than, let's say, $1,100 a month gross. Remember that. And so a lot of times you can talk to your employer. If you're working by the hour, reduce your hours, go to even less than part-time, because even working part-time is probably going to gross more than $1,100 a month. So reduce your hours down to even less than part-time, and that keeps you from being denied at step one in the disability process, is that you're still continuing to work and making over the statutory limit. I would also say that if you are getting to the point where you're unable to work, look at the reserves that you have. What sources of income can you put together, especially for the first 5 months? If you stop working and you file for disability, then one of the things that's going to happen is you're going to get put on a medical hold, or even a technical hold, if you will, that you're going to have to sit out 5 months because that's considered short-term disability. So a lot of people file right after getting laid off or being terminated. And the reality is that when they file, the case just stops right there at the local office, and it stops for 5 months. Sometimes Social Security makes another inquiry as to whether or not you've gone back to work, or if they send the case then on down to the State Disability Determination Service after waiting a full 5 months. So realize that even on a quick claim, a quick disability claim, if you file before that first 5 months, then your case is going to be held for 5 months, and it's probably going to take the DDS service, the Disability Determination Service in your state. It's going to take them, another 4 or 5 months right there. So you stop working. Obviously, we're talking about and you file right away. Well, obviously, we're talking about easy math here. That's 10 months that you're out of work without income. So evaluate your sources of income before filing. Can you hold on and work a little bit longer, put some money away, or sell unnecessary items, an additional car, things like that that will help you get through this period of time while your case is being determined. By the way, and another really important thing here too is no SGA. And what I mean by that is no substantial gainful activity. That, again, we're referring back to step one, that you're not working full-time or even part-time and making over $1,100 a month. If you do so, if you file, you wait a couple of months, and then your income, you're still working even, and then your income jumps above that level, well, you can cancel out all the months prior to that you would receive back pay. And plus two, you put your claim in jeopardy, your disability application, your claim in jeopardy. So, and let me also tell you as well, for those that are successful in getting disability, and you go back and you work a little bit while getting disability benefits, and almost everybody does, because at the very best, you're only going to be able to be paid 80% of what you were making the year prior when you were working. So that's if you've got other sources of income. Social Security will often come in and reduce their payment to keep you at that 80%. So what is really important here is to understand that if you do get on benefits and then you go back and you start working because it's hard to make ends meet, and you get above that SGA level, that $1,100, well, guess what? You run the risk of Social Security saying, hey, after reviewing your case, hey, you're not disabled. As a matter of fact, you owe us all the money prior to that we paid you because you weren't really disabled. So I can't emphasize enough how important it is to stay below the statutory income amount. If you have a 401k and you're getting money from a 401k or a retirement account, things like that, that doesn't count. SGA means substantial gainful activity. And in order to engage in substantial gainful activity, you have to do work that is both substantial. And what that means by doing work that is substantial is you're just not a vegetable in the corner and somebody's feeding you a paycheck. You're doing work that's needed by your employer. And so work is almost always going to be substantial unless you're working for your mother or father, a family business, because an employer, it probably has limited resources to pay to you. And this is actually important, the point I'm making here. And it's got to be both substantial and gainful. Gainful meaning it's making over that statutory limit, that gross amount each month that you're allowed to bring home. Okay, so if you're making over that amount, Social Security assumes that your work is both substantial and gainful. So the burden would then come upon you to show that the work was neither, substantial. If they know whether or not it's gainful, because they can see, your earnings are reported to the Social Security Administration. Very tough burden to overcome, by the way. And not too many people at the Social Security Administration are willing to listen to you. You may try to make your argument to an administrative law judge, but you may very well fall flat on that as well. Okay. So the last thing I would say before getting ready to file is pull all your own medical records. Believe it or not, you need to do it. Now, some people have been to 15 different hospitals, 12 doctors, and it's overwhelming to do that. But where you know that you went and received primary care for the condition in which you're filing for, you need to pull those records, you need to read those records, and you need to submit them in yourself. Or if you choose not to do that, contact that doctor, talk to the nurse, talk to the office manager, and make sure that the request was made and that the records were sent back to Social Security. Okay, that brings up a number of points. So if you went to the doctor 10 years ago and you're just now filing for your disabling condition and you haven't been back to the doctor, then don't pull the records, because the records don't matter anymore. They're completely irrelevant. So if you're needing to file and you had an injury 7 years prior, but you've just been living with it, then you need to go back to that primary doctor and you need to start getting medical treatment again. And you need to have the doctor establish in your medical records what type of limitations that you have. So while you may have gone to the doctor or the hospital, 10 times at 10 different places, really it comes down to one to three places of medical records that really show you were disabled. And that's really important, because if you are if you're lackadaisical about sending it in or getting your records in order, Social Security has a rule, and that rule says that even with the most sincere allegations of a severe condition, and you may be the most trustworthy and believable person in the world, without medical evidence to back it up, you're not going to win your case. And so what I tell most of my clients is when we have this discussion, for those especially that haven't been to the doctor in a while, and I tell them, look, you're at a crime scene basically. Picture yourself at a crime scene. There's your career and everything else laying dead on the street. And you got to find out who done it. And so you need to gather medical evidence just like it was a criminal case to prove the allegations. You're making an allegation that you are no longer capable of working because of a severe condition. Well, you got to prove it. And you can't just do it on your word alone. So before you file, most importantly, get those medical records together. Let's just say for a lot of people that have been out of work, they're having to go to county. And if you're in Dallas, for example, you're going to Parkland. And so go down, request the records from Parkland, and make sure that it's a thorough record of you having a condition that keeps you from working. So anyway, hope this helps. See you tomorrow.